Welcome to the phone line, everyone. Ideally, people are making their way onto the phone and can hear me. The phone is in lecture mode, so you should be able to just hear me. If you want to mute your phone to make sure that you might not leak through, you can do so by dialing *6. If it turns out that you've got sound quality problems in terms of you're not hearing well, or there's any other technical questions or concerns, hopefully we've got them all dealt with. But if that happens at any time from now till we're done, you can dial *0, and that should take you directly to a pragmatic operator. And if you want to disconnect from the operator and return to the conference, you dial *0 again. Now, this is good. Just remember that this is going to take you to pragmatics operators and not to our folks at the Environmental Law Center. But it's pragmatic that we'll be able to deal with problems on the phone line. As we mentioned on the piece that we were keying in, use the chat window to direct questions to Leah or directly as a private message. She'll be compiling them throughout the presentation and then posting them on the chat for me to answer when we wrap up the bulk of the presentation. And if we're not able to get to all the questions in the time period, we will be posting responses online over the next few days, and we will also be posting the recording of this session and the slides. So we're not too far in. Hopefully people have got most of what we've needed on what's shown up on the chat. So we're just getting into touching on what's Alberta Environment's jurisdiction, or in terms of what does Alberta Environment have authority over in terms of regulating and decision making. So their authority comes from the Water Act and the Environmental Protection and Enhancement Act, or EPA, which is how I'm going to refer to it for the rest of our time here. And so you see there's a wide range of activities there. A lot are dealing with substances, things that can affect the environment in terms of substances that can have adverse effects, dealing with water, how water is managed, both the use of water, drinking water, activities that can impact the waterborne environment, activities that can have an impact on land and air, land restoration, both through reclamation and remediation, as well as greenhouse gases. So while that looks like a fairly complete list, when we flip to the next slide, you'll see that there are a lot of pieces there under what you'll see as termed as frustrations that don't quite fit in. Now, the reason why that is that EPA came into effect in 1993. It was being worked on about 20 years ago, and it was an effort to consolidate a whole range, about 7 different pieces of environmental legislation that Alberta had. So while it was a step ahead in terms of bringing those pieces together and consolidating authorizations so that a facility, say an industrial plant, didn't have to go out and get 4 or 5 separate authorizations. They could get one authorization, and so the air and the land and the water could be dealt with all at one time. It still doesn't cover off everything. There were lots of other types of decisions that could have an impact on environmental issues that were being made by other departments. So we'll flip over to this next slide, which tells you a little bit more. So people will get frustrated because they deal with Alberta Environment, and there are a range of things that aren't in Alberta Environment's jurisdiction. So things like zoning, which comes under the authority of municipal governments. And there may be the potential with the new Alberta Land Stewardship Act and the move to the implementation of the land use framework that a part of these zoning decisions may also be influenced by what's developed through the regional land use plans and the land use secretariat. So that's a piece that's not Alberta Environment's to decide with. Oil and gas exploration, which is covered off by the Department of Sustainable Resource Development. Parks and land protection, which is predominantly dealt with by the Department of Tourism, Parks and Recreation, and as well by Sustainable Resource Development in relation to public land. Agricultural activities, and the Natural Resources Conservation Board, or NRCB, has the authority to regulate in relation to what's termed in the legislation confined feeding operations, or also known as intensive livestock operations, big feedlots, and as well species at risk unless it's being considered as part of an environmental impact assessment. Species at risk at the provincial level are dealt with by the Department of Sustainable Resource Development in relation to wildlife, and if there's a federal aspect to it, it'll be dealt with by Environment Canada. So there can be, in any particular development, it may not be Alberta Environment that has the bulk of the decision-making authority or much decision-making authority at all. And so people do end up getting frustrated often when they deal with Alberta Environment because Alberta Environment only has a piece that they have the jurisdiction under their legislation to deal with. And so that's a limitation. That's not anything that can be fixed unless the government looks to go in and change how decision-making is made and change legislation to shift around who has jurisdiction for what and who has decision-making authority over what. Another challenge and what can cause problems and frustrations in relation to authorizations and environmental decision-making is the whole issue around cumulative impact. Because while the current legislation we have, particularly in EPA, touches a bit on cumulative effect, it's not well dealt with, and there's not anything that effectively integrates the impacts of different activities in terms of decisions are made on a case-by-case and a site-by-site basis. So there's nothing that really says, for instance, if you were to look at, say, the industrial heartland region up by Fort Saskatchewan, that steps back in that decision-making of authorizing those activities and looks at it as a whole to say, okay, if we've got 4 plants there or 4 upgraders there, what's going to be the cumulative impact if we add a 5th in or if we add a 6th in? The decision-making has traditionally and continues to be on that site-by-site basis. And so it's an incremental approach. The approach of government, I think, has been traditionally as well to, if they can approve something, ideally to do it, even if it needs a lot of conditions on it. So there's not a lot in the big scheme of things. There's not a lot that gets turned down. Generally speaking, things will often be approved with lots of conditions, and then if the operator can't meet the conditions, then that tends to be what prevents it from going ahead rather than government saying no. And as well in relation to cumulative impacts and any of these things, there is a certain amount of discretion that's there on the part of the decision makers. Now, part of that is to give them flexibility to be able to make decisions and to deal with those site-by-site circumstances, but as well the discretion also often gives them the ability to just focus in on the particular piece and not to look at the broader piece. So those are some areas where some of the challenges arise. So we're going to move on now and just briefly go over for you what the different types of authorizations are under the Water Act and EPA, and touch on those. And obviously you can see the little red no there, which is showing those are the forms of authorizations where there's not any provision for public participation or public involvement. So essentially that's just interactions between the applicant and Alberta Environment as the regulator. So what we're going to focus on with this webinar is on the top two, the approvals and the licenses. So approvals under EPA, I'm going to start with that, and those you figure out, well actually first off, just talk about approvals generally under both EPA and the Water Act. These are the most detailed form of authorization that Alberta Environment grants, and they focus on activities that are most likely to have a significant environmental impact. Now, as I mentioned earlier about site-specific, these are site-specific, so it will be a specific regulatory document or a regulatory authorization that's put together and written for a specific facility or specific activity, and they will contain specific conditions for that are put together for that activity or for that facility. Under EPA, they tend to be specific in terms of, they list it out. So there's a regulation called the Activities Designation Regulation under EPA, and Schedule 1 of that regulation lists out all the range of activities that are required to have approvals to be able to operate in the province of Alberta. Now, by contrast, under the Water Act, it's a bit different approach. There it's more of a broad catch-all. In terms of under the Water Act, they say activities that require approval is all activities that affect water bodies and that aren't otherwise regulated or authorized under the Water Act. So it's much more of a catch-all, and things are exempted out rather than a specific list. And so section or page 29 of the guide sets out a number of exemptions, examples of exemptions. Schedules 1 and 2 of a regulation under the Water Act called the Water Ministerial Regulation lists out what exemptions are from the requirement to get approvals under the Water Act. So that's That's really the distinction there between them, but both of them are intended to be site-specific, are looking at particular activities that have the most likelihood of causing some significant impact to the environment. Now, the water license is a bit of a different bird. The water license is focused predominantly on water diversion. So that's basically what you are hearing about when you hear about parties having a water license with a right to divert water, whether it's surface water or groundwater, to divert that water and to use it. Water licenses also apply to structures that may obstruct or interfere with water flow. So things like dams, weirs, canals, those types of things. So that's where the water licenses come into play. Just to touch on really briefly the other pieces, because the one that you may hear the most about otherwise is registrations. Under EPA, registrations are sector-specific authorizations. So rather than being for a specific activity, they will cover a broad sector, such as asphalt paving plants, that's the one that's popping in my mind, landfills, pieces like that. And so they're linked with documents that are called codes of practice, which essentially set out the rules of the game in terms of how you would operate that activity. So someone who's going to operate that activity applies to Alberta Environment for a registration, and if they get the registration, then they're given a registration number and directed to operate in accordance with the relevant code of practice. Under the Water Act, again, it's a bit different. It deals with specific water allocations that are related to traditional agricultural use, and there is also a time limitation tied to them in terms of that it relates to traditional agricultural use of water prior to 1999, and there is also a time limitation in terms of registration. So again, that deals with water use, but a very specific water use. So to move on, in terms of part of what part of also what I would like people to think about tied in with this is while we're focusing and our guide focuses on the regulatory process, is that the regulatory process is just one piece of broader environmental decision making, and so there is different forms of participation. And if you think about it almost in terms of if you as a member of the public want to engage in environmental decision making, think of it as tools in a toolbox. And so what we're focusing on here with this webinar is predominantly on one tool, which is the regulatory process and how you can use that tool to influence or have a say in environmental decision making. But there are also more informal means that we'll touch on in terms of being involved in the decision making or looking to influence the decision making. So in the formal or the legal process, in terms of what's covered off in the legislation, there's clearly the director's decision on the authorization, which is what we're going to focus on. There is also, out of the director's decision, there is an appeal to the Environmental Appeals Board, and we're not going to get into that in detail. That's actually covered off in the next webinar, the Part 2 webinar that will be presented next week. And also there's the opportunity to participate through the EIA, or Environmental Impact Assessment process. Now that's part of the Part 3 webinar, which is happening 2 weeks from today. So those will be coming up, and we're not going to get into a lot of detail otherwise about that. But as well as shown here, there's a whole range of informal processes available for the public to participate, and that can be one-on-one, through groups, a whole range of opportunities. And so where you're concerned about environmental matters or developments that may be occurring around you, and you want to engage, you should, ideally what you should do is be thinking about the whole range of possibilities that are available to you and how those different tools in the toolbox might look to gain the results that you're looking for. So in terms of the approval process, and when we put this together, it had lovely sequencing to walk you all through it, but that's fine. It's all here, and it should be relatively straightforward to follow. In terms of the approval process, which will also tie in for the water licenses, but effectively what happens is that an application is submitted by, I'm going to use the term applicant. You may also hear, when you look at our materials, see the term proponent. And basically what that means is whoever the operator is who's wanting to carry on that activity, get that authorization. So an application comes in, it's submitted to Alberta Environment, and it goes to the attention of an official called the director. And the director essentially is a designated official within Alberta Environment that has specific duties, powers given to him or her under EPA and or the Water Act. Now, the director doesn't do it all themselves. They have a staff that would provide support and would do a lot of the work. But the name you're going to see is the director, because that's who ultimately, whose signatures goes on, who the decision making is made, is done, and whose decision goes on from there. So the material goes to the application goes to the director. Now, part of it is the director can look at it and decide whether or not they feel it needs to be reviewed from an environmental impact assessment process. And so if it does, it moves into that process, will be reviewed in relation to the broad environmental impacts. Once that process has been completed, then the application is returned back to the director to deal with either the approval or the licensing application. So there is an EIA loop, and Adam Drydzak of our office will be dealing with the EIA portion in 2 weeks. So I'm not going to get into detail or steal his material. So once the director is ready to proceed with the application as a whole, then public notice is given to make people aware that an application has been filed. The notice also will make people aware of where information can be obtained in relation to that application, and it also triggers essentially the step where the formal step for people to participate by providing what's termed the statement of concern. And we'll talk about more of the details of that in another slide or two. But the statement of concern is a key piece in terms of people participating in this process. So the statement of concern is provided by people to the director, and so it feeds in as part of the decision making and part of what the director takes into consideration. As the director and his or her staff are going through and reviewing this material, they can also, whether it's on their own volition or from what's raised in the statements of concern, require the applicant to provide further information and make that available. And then ultimately it's all considered and a decision is made with respect to issuing an approval or a license. And following from that, there can potentially be an appeal, and we'll touch on that a little further. So if you're looking to participate, you'll see a notice come out, and you may want to engage. And so part of the challenge is, how do you find out more? How do you find out more information? How do you get what you need to know to figure out what are your concerns, what are you going to raise as your concerns, and put that all together in a form to get to the director. So the notice will indicate where the application information is available, and so often the information is available directly from Alberta Environment as well as directly from the applicant. Depending on the scope of the project or the application, it may be made available elsewhere. It's fairly common, particularly for big projects, for applicants to file the application information as well, to make it available through things like a local public library, municipal office, those types of things. Now, in terms of if that doesn't give you enough information, where do you go to? So the rest of this slide touches on what's provided for in EPA and a regulation under EPA called the Disclosure of Information Regulation. And basically it sets out a process for how you go about getting the information. And so your first step is to go to the applicant and ask them for the information. And so the applicant has a certain time to get to you, and if they refuse or fail to provide that information, then you are entitled to go to Alberta Environment to ask to have that information provided. So there is that in terms of when you put the request into Alberta Environment or to the applicant. Generally speaking, there's a period of 30 days. So they have 30 days to go look for that information and to provide a response back to you. Now, if you don't get the information from the applicant and you've got to go to Alberta Environment, part of what you want to provide or you're going to provide to them is in terms of the steps taken to show that you went to the applicant first and asked for the information. So how you went about doing that. You're going to indicate that the applicant failed to provide you with the information, so you'll want to provide them with information, details about dates and that. And also talk a bit about why you're wanting this information. Now, one thing that I will flag for you that's in the Disclosure of Information Regulation, if you're engaged or you're involved with a group that may have an interest in this project and they've been engaging on this as well, before you're asking Alberta Environment, you will want to check and see if they have the information, because the director, under the Disclosure of Information Regulation, does have the ability to refuse disclosure if the document or the information that's being sought was already provided to a group or an organization with whom you're affiliated. So say for instance, if you're living in Edmonton and your local community league has been involved in it and has gotten some information from Alberta Environment, the director could say, well, you're a member of that community league, we've given it to the community league, so go get it from them, we won't provide it directly to you. And part of it is that they're not looking to be difficult, but it's in terms of again, efficiency. So part of what you're wanting to do is, this is part of what kicks into in terms of doing your homework, I guess, in terms of if you know or you're engaged with other organizations or groups that are involved, is comparing notes, seeing who's got what information and what's available there. So in terms of, there are a range of sources, as we've mentioned, for information. As we mentioned, government, and that can be not only the data that's provided into government by the applicant, but things like policies, guidelines, or objectives that are relevant or could be relevant to the application that's going before them. Reports on things like, they may have reports such as dealing with the air quality or the water quality in the area that's being considered for that particular application. Obviously the applicant, and we've got listed there on the slide many of the kinds of information that you can look to get from the applicant. You could look to contact experts, and that may be either in the private sector, in academia, where they may have done research on issues that are relevant to the application or that. And as well, NGO or non-government organizations, if they have been involved on the issues, they may well have relevant information as well. So there's a whole range of sources that you can look at. Before we go a little further, I'll mention I'm hearing a little bit of someone's audio coming through, so if you want to check, and if you're not sure if it's you or not, if you dial *6, that will clear that up. Thanks. So then in terms of public information, and what this refers to is what is considered or what is designated as public information, or information that's publicly accessible and must be disclosed to the public under EPA and the Water Act. So this arises out of Section 35 of EPA, and as well there is a ministerial order that was issued by the Minister of Environment in 2004 that expands the range of information that can be made available. So this is information that's either in the possession of Alberta Environment or has been created directly by Alberta Environment. And so there's a wide range of information that's available there in relation to an application. So not only the application form itself, but information in support of that application, reports or studies that have been generated under an approval. And part of this, while we're talking about applications here, that this process applies not only to the first instance of someone applying for an approval, but also, for instance, under the Environmental Protection and Enhancement Act, approvals are set, generally speaking, for 10-year terms. So this will also apply to when an operator applies for a renewal of that approval, or when they apply for an amendment of the approval. So this same process will apply. So if you've got an operator that's been operating, say, for the past 10 years, and they're applying for a renewal of their approval, it still goes through the same process in terms of notice, the opportunity for the public to participate, provide statements of concern. So that's where you can look to access reports or studies that they've had to submit over the life of their previous approvals, and look at that to see what their past operating track record has been, for example. So monitoring data has to be made available, as well as the processing information. So they can't just give you a bunch of numbers, but you can also ask for the background data to help you understand that information. Similarly, with information coming out of environmental impact assessment reports, the background data for that is also accessible. Statements of concern can be public, and if the public notice that's given whenever an application comes in, it will mention that a statement of concern can be provided, and it mentions very clearly there that statements of concern will be made public. So if you're putting together a statement of concern and filing it with the director, part of what you need to understand is that is going to become a public document. So anyone else will be able to access your statement of concern. And as well, enforcement-related documents can be public information. There is a little proviso tied in with that, and I'll touch on that in the next slide. The other thing that's not showing on here is, and this can become relevant at the back end in relation to appeals, is that the director's notice of a decision, and so a decision whether or not to grant an approval or a license, is publicly accessible, and that includes the direct notice that the director would give to the applicant, to people who have provided a statement of concern, or others. So there's a broad range of information. Alberta Environment, relatively speaking, as compared to a lot of decision makers, is relatively open and fairly transparent, and does offer up a fairly broad range of information as being publicly accessible. So there is a fair bit that you have the right to ask for. Now, in terms of barriers to information gathering, now part of what I will flag for you in this is in relation to these first pieces on privilege. This is not solely in relation to information that you would get from government. So, for instance, if you go and ask the applicant for information, there is the chance that you may run into a claim of either solicitor-client privilege or litigation privilege, both of which tie in with in terms of how that organization, so the applicant, how they're interacting with their lawyer. And so generally speaking, solicitor-client
privilege really? You're skipping out there.
Ties in with the communication between the lawyer and the client. Litigation privilege ties in relation to documents that are prepared specifically in relation to the contemplation of litigation. Now, I don't know that that will arise so much in relation to approvals or licenses. Where it tends to arise more in terms of those kinds of claims tends to be more so in relation to enforcement situations, those types of things. But those are possibilities that may be raised. As well, there is a long-standing tradition legally in terms of what's termed crown privilege, or essentially a government privilege. And what that ties in more so is in relation to the communications back and forth between government ministers, that type of thing. So, for instance, if the Minister of Environment is sending a memo off to the Minister of Sustainable Resource Development where they're discussing potential impacts of a proposed activity on that type of thing, it's not likely that you're going to get access to that, that's going to fall under the Crown privilege. Now, under Section 35 of EPA, which deals with public disclosure, there is the possibility available to applicants to ask Alberta Environment to hold information as confidential and not to disclose it. Now, this is a fairly limited piece, however. They can only ask in relation to trade secrets, processes, or techniques that they keep confidential. So, for instance, they can't toss in their whole application and say, I want you to hold it confidential. They have the onus of proving to the director that it's in relation to these particular processes or techniques, trade secrets, that they're holding confidential and that they need to be maintained confidential. So the director will review that request. If it's granted and that's information you're wanting to get access to, then there's two routes that you can look at in terms of trying to get that access. One is to do a Freedom of Information request under the Freedom of Information and Protection of Privacy Act. And that's an option that's available to you. Practically speaking, part of what you need to keep in mind is that can be kind of a time-consuming process. And so you may not get the information you want in a timely enough fashion to fit into the approval or licensing process, the timeline that runs on. So you can look at that as an option, or you could look at applying for judicial review in terms of resorting to the courts. Now, judicial review is limited in terms of it deals with how the director made the decision. So it may or may not get you the remedy that you want. It's dealing more so with that than the substance of the information. The other piece where you may have difficulty getting access to information is in relation to investigations, because Alberta Environment, while it mentioned on the previous slide in terms of publicly accessible information about enforcement, where something is the subject of an ongoing investigation and or prosecution, Alberta Environment is not required to publicly disclose that information until such time as the investigation and prosecution is complete. So while something is going through an investigation, going through the courts, that information is not going to be publicly available, and that's geared at protecting the integrity of the process and ensuring that there's a fair hearing in the courts. So in terms of participating in the director's decision, the notice kicks off a timeline. So there's a set time period for filing a statement of concern, which is your means of participating in the process. So either it will set a specific date in the notice, or, and this is much more common, it will set a time frame. And commonly it's 30 days for approvals under EPA and for the license under the Water Act. And the license under the Water Act, remember, is the right to divert and use water, or where something's being built that's going to obstruct the flow of water. However, it's only a 7-day period for a Water Act approval, which are certain activities that may affect water. So there are certain timelines, and both timelines may apply. There may be certain activities that need both an EPA approval and a Water Act approval. And so there may be both of those timelines. So part of what you really need to pay attention to is in terms of the notice itself. Now, if you have a look at pages 84 and 85 of the guide, those set out sample notices, one under the Water Act and one showing you a sample notice for an oil upgrader. So it brings into play the Environmental Protection and Enhancement Act, that the ERCB has a role. So it gives you an example of what a notice looks like there. So part of what you need to do is to read through the notice really carefully, and it should lay out for you what acts apply and what timelines apply. And so where there may be more than one authorization involved, you may need to file a statement of concern for each. And part of what you need to come at then is being clear as to what your concerns are and what you're looking at there. In terms of the statement of concern and what to include, I guess people should not find the term statement of concern daunting, because it's not a particular form. It's not that you have to provide a sworn affidavit or anything like that. It can be a letter going to the director, but ideally it's something in writing that's going to the director. Now, the first step in terms of what do you include is you have to show the director that you're what's termed directly affected, that you're somehow going to be directly affected by this decision, and that's essentially the criteria that's set out in the legislation, both in EPA and the Water Act. It talks about that statements of concern can be filed by people who may be directly affected by the director's decision on these applications. So in terms of how that's been interpreted in the past, part of it deals with residency and land ownership in terms of how close are you to the proposal, geographically speaking, in terms of what kind of impacts will there be on your land, on the water that you use, on your health, or an economic interest that you have. And that may be either property rights that you have, if it's going to affect somehow your ability to earn a livelihood, those types of things. Are there any impacts on common law regulatory rights that you have? And this comes into play more so in relation to the authorizations under the Water Act. So do you have some rights of your own to water, and will this authorization affect how you use those rights? Now, part of what's can be relevant but hasn't been traditionally considered as being directly affected is in relation to recreational impacts and recreational use. So if an activity may affect your recreation, that may not in and of itself give you status as being directly affected, but it may be relevant. Or if you've got an established environmental concern for an area. So if you've been part of a group and you've been working to protect an area to help protect the status of an area, that type of thing, that may come into play. Part of what you want to demonstrate to the director in your statement of concern is if there's anything that makes it distinctive, that the impacts are more distinctive for you than, say, the average Albertan. What's the distinction there? And the key is that directly affected status is central to participation. Directly affected status is what gets you in the door. That's what the director is going to look at in terms of which statements of concern he or she reads through. It affects who will get notice of the direct notice of the decision to issue an approval or a license, and as well it ties in relation to the potential to have the right to appeal that decision to issue an approval or a license. So the statement of concern is really a key piece, and establishing directly affected status. Now here we've got the point about piggybacking participation. And so what that ties in with is that often it's easier for individuals to get in the door than groups. So if you're part of a group, part of what you want to look at is to see that you can qualify at least a few members, if not more the better, in terms of them having their own individual status as being directly affected. So where you're engaged with a group, what you'll ideally want to do is have a number of your members file individual statements of concern, as well as looking at putting together a statement of concern for the group as a whole. Part of what you're going to want to do in a statement of concern is cover off both your general and your specific concerns. So you may say, I'm concerned about water quality generally, but then you may have some more specific pieces in terms of, you may say, and I'm concerned about water quality generally and the effects this may have, and I'm much more specifically concerned about the effects this is going to have on the habitat and breeding of the speckled trout population that's in the waterway that may be affected. So you want to lay out both those specific and general concerns. When you're putting together your statement of concern, what you're going to want to think about is what's your bottom line? What ultimately are you looking to achieve? What can you live with? What can't you live with? And be clear on that, because if what you want to achieve if you're looking ultimately to have this project turned down, which is a big task, because generally speaking, most things will get approved, even if there's lots of conditions on them. But if ultimately your bottom line is this, you want this stopped and nothing else, you may need to use other strategies besides simply participating in the regulatory process, and we'll touch on those. If you're looking at saying, if your bottom line is more so in terms of saying, well, I'm okay with this going ahead with these types of conditions attached or with these sorts of parameters around it, then you want to think about what kind of conditions are there that you would like to see. Are they reasonable? Who's the applicant? Are they going to have the capacity to meet these conditions? And that's part of it. If you think that the applicant doesn't have the capacity to carry off the project or the activity in a way that's going to be safe for the environment, then that's part of what you can raise questions about and put into play for the director to consider. Part as well of what you're going to look at, or what's going to come into play, and that you can look to bring this information into your statement of concern, is why you're looking for these conditions, or why you're looking to have the project refused. What's the likelihood of the impacts? What's the potential degree of these impacts? How clear is it that the proposed activity is going to cause the impacts that you're anticipating? So what's termed as the causation. How clear are the links between the activity and what you're anticipating are going to be the impacts? And is there any expert evidence available, whether you've generated it or commissioned it, or you've been able to find it from other ways? What kind of information might be available to back up your concerns? So this next slide, and I'm not going to cover it off in detail, recognizing one, the time, and two, that we're going to have this posted up later so people can go back to it. But this, as well as the guide, also provides a list, and this shows some of the common classes or categories of conditions that can be put by Alberta Environment on an approval or a license. So there's a wide range, and particularly in relation to operating, they can tend to be fairly specific. It's not as common for Alberta Environment to say, here's the endpoint you want to get to, use whatever process you want. Generally speaking, in the past, what they've looked at is that, particularly for industrial operations, an application has come in and it has said, we are using this process, we're using this machinery, we're using these techniques, and basically once Alberta Environment approves them, they are pretty much bound to those pieces, or to meeting certain standards or requirements. So the the conditions can be fairly specific, and so you have some leeway there. So to give an example, I guess, a number of years ago, and this was on an amendment to an approval, Inland Cement in Edmonton had applied to change the feedstock for their processing in terms of what they burned in their furnace from natural gas to use tires, because it was at a point where the price of natural gas had peaked. And so part of that, now this had to go all the way through to appeal, but part of what it ultimately turned around was the question of the kind of process that they were using and the kind of equipment that they were using to screen particulate matter out of the emissions that were expected to come, and that there would be increased emissions coming from burning used tires versus burning gas. And so ultimately, as it rolled its way through the appeal, while the fuel switch wasn't changed, that was approved by the director, but what was changed was in terms of that through the appeal process, conditions were imposed that required Inland Cement to use a much higher form of technology in relation to screening out those particulate emissions than what they had originally proposed. So that's the type of thing is you can look at that and get into a fair bit of specifics on that in terms of what you think might be acceptable. Now this is what I refer to as a little known secret. It's in the legislation, actually in the Approvals and Registrations Procedure Regulation, but it's not really well known. And under the Approvals and Registrations Procedure Regulation sets out the detail in terms of how the approval process proceeds. And so that's one that's useful to look at just in terms of giving you more of the details as to how it proceeds. But part of what it provides in Section 8 of that is that before the director makes a final decision, he or she can circulate a proposed approval to the applicant, to anyone who filed a statement of concern, and to anyone else the director considers appropriate. And so it's very common for the director and Alberta Environment staff to circulate a draft approval to the applicant, and there will be back and forth discussion around conditions. But very few people know that someone who filed a statement of concern can ask to be included in that and to have a look at the proposed approval. And so what we're suggesting is that, one, you ask for this opportunity in your statement of concern, and that you otherwise ask the director and keep after them a bit about it in terms of saying, you know what, your legislation says you can do this, and we would like to be engaged in this way. And that takes you a step further than simply providing the statement of concern. It's another step down the way. So in terms of, we refer to a bit to outside strategy or looking at other options. Now this is touching on perhaps some of the other tools in the toolbox. So when an activity or a development is proposed and you're looking at it at the outset, part of what you want to ask yourself is about what do you want to achieve? What do you want to get out of potentially engaging in this process? And what are the different tools that you can use to look to gain that end result? And so a lot of this tied in particular with what's commonly termed outside strategy, gears around relationship building. And I realize some people will roll their eyes and think, oh geez, all that warm fuzzy stuff. But practically speaking, it can make a difference. So part of it is going the political route in terms of talking to your MLA or other MLAs, looking to lobby your municipal councillors, because then you, if you can catch their interest and their concern, then ideally you have another voice with some influence who can be lobbying on behalf of your concern or your issues. Contacting the Premier or relevant ministers as well. You can look at going to the media, and they're looking to generate a story. I would suggest to some extent that you will have easier pickup at times with smaller media rather than going directly to, say, the Edmonton Journal or the Calgary Herald. To some extent, the smaller, more local papers, neighborhood papers, rural papers, may be more likely to pick up a story unless you can have some really sort of compelling hook that they think is really going to catch the eye of the public. Now, the one thing that you need to balance out in that is that at times taking something into the media, while it will get you a lot of attention, can also shift the interaction to a more adversarial type of position. So that's something that you need to weigh in terms of if you're looking to go to the media. Part of what you need to do to be successful in terms of getting things out to the media is, again, building relationships, getting to know the media people, how they work, what kind of information they need, and as well accuracy, providing them with accurate information. And as well, you can do networking. Within the community, there's a whole range of interests in the community that may share your concerns, and with groups, including non-governmental organizations, environmental groups, landowner groups, watershed groups. There are a whole range of people who may share your concerns, health-based groups, church groups. There's a whole range. So a lot of it is, again, sort of the more momentum, the more concern you can build around your issue, the more you're going to catch government's attention, the more you're potentially going to catch the director's attention, and looking at how you can influence that outcome. Now, with any of this, whether you're using outside strategy, participating in the regulatory process, or a combination of all of those, a few things you want to do is you want to make sure that you're documenting all communications. So you're taking notes, you're keeping copies of anything that you send out in terms of letters, emails, faxes, anything like that. Don't necessarily take folks on their word or what they've told you verbally. Look for written confirmation. Seek clarification where there's gaps or confusions, where you're not clear about information that you've been provided, what government has told you or what the applicants told you, to look to make sure that you're clear on your understanding. And when you're involved in the regulatory process and you're dealing with Alberta Environment and the applicant, it's really important to keep a cool head. And while your concerns may be very personal to you, you need to recognize that these folks are not out to screw you over personally, that they're there doing their jobs as well. And so you shouldn't be dealing with them in a disrespectful manner, expressing threats, anything like that. That's really not going to get you any further ahead and may well set you back. So it's fine to, it's fine to be concerned. It's fine to be, you may well be angry, agitated, but look to deal with them in a level fashion. So in terms of the other thing you may want to consider when you're looking to engage in something like this is looking at participating as a group. So we've got laid out here the benefits and the disadvantages, and really what you need to do is balance it for yourself and make the decision for yourself based on what are your concerns, what do you think you can gain by being involved in a group, and are your concerns consistent with the groups, or do you have some pieces that are distinctive to yourself and that are important enough to you that the group may not adequately represent them? So really it's going to be a personal decision for any of you who may engage and looking at what you can gain through participating in a group versus what the disadvantages may be and whether or not it's going to gain you the points that are really important to you. Now, as I mentioned earlier, it's also important, given because sometimes groups can have challenges getting in the door, to look to try and establish individually that you're directly affected. So you can look to go in with a group, but you should still look at filing that individual statement of concern. So in relation to, you've gone through, you've filed your statement of concern, the information has gone through, the director's considered it, or to the point where the director's making the decision. So as I mentioned, there's a couple of notice points. So once the director's made the decision, then they're obliged to give notice of that decision, and most commonly they are deciding to grant an approval or a license. So notice has to be given directly to the applicant and as well to anyone who has filed a statement of concern. Now, part of what I'll point out there is a fine distinction, because the director doesn't automatically accept every statement of concern or everything that's filed with him or her as a statement of concern. They take a look at it and make a determination on whether or not they think someone's directly affected. So if they think you're directly affected, they'll let you know, and then you will get direct notice of their decision on the approval or the license. If they don't think you're directly affected, they'll let you know that, but then you're not going to get any more notification from them in relation to that process. Now, that's where I mentioned earlier about that these directors' notices are publicly accessible information. So it takes you more legwork to track that in terms of when the notice comes out. Now, the notice has to be provided within 30 days of the director making the decision on the approval or license, and it does have significance in relation to appeals. So there's a timing consideration, because when the director gives notice, that then starts the time clock running for appealing the decision to issue an approval or a license. And again, it's a 30-day piece for EPA approvals or Water Act licenses, and a 7-day piece for Water Act approvals. So that's, again, where you need to be really conscious of the timing. And for appeals, to be able to appeal, you need to have filed a statement of concern. Now, if you filed what you think was a statement of concern and the director said that they didn't think you were directly affected, that doesn't necessarily bar you from filing an appeal, because the Environmental Appeals Board makes its own determination on who's directly affected. But recognize that that is a fence you're going to have to climb in the appeals process, because the director will look to fight your being there on the basis that you're not directly affected. So the statement of concern is a key piece. The timing is a key piece. The other thing just to flag for people is in terms of the cost of participating in this whole approvals or licensing process itself. It differs from appeals or the court process in terms of that costs are not generally recoverable. So if you're going in and participating in this regulatory process, generally speaking, you're doing it on your own dollar. Now, you may look at, and it is something that has occurred in the past, and certain applicants are open to that possibility, is you may want to look at getting into early discussions with the applicant, and again, this goes back in part to relationship building, is in terms of discussions with respect to whether or not they can provide you with some assistance. Are they, for example, willing to fund an expert that would help provide an independent review of some of their reports or some of their application materials? And that's been known to happen at times. So that is a possibility. But generally speaking, otherwise, there is no way for you to look to recover a portion of the costs of your participation in this piece of the regulatory process in terms of the approvals and the licensing process. So that covers off essentially the bulk of our substantive piece, our substantive content on this. So just to sum up in terms of really the key elements for you to take away from this. One is to recognize and remember that there are limits to Alberta Environment's jurisdiction, that there is only certain things that Alberta Environment has the authority to deal with. If they exceed that authority, it's something that is appealable to the courts. So if they exceeded their authority and gave you a decision you liked, it's likely to be overturned anyhow. So recognize that there's limits to their jurisdiction, and to bring the concerns that you bring to them in participating, keep them within the bounds of that jurisdiction. Keep in mind in terms of the type of authorization that you want to engage on, because there's only those ones, the approvals under EPA and the Water Act and the licenses under the Water Act, that provide for public participation. So there's limitations there. In terms of gathering information and all the options that are available to you in terms of where you can get information and how to get it, the timing elements, which are a real key piece, particularly in terms of you need to get your statements of concern in within the timelines, and it becomes relevant in relation to the potential to appeal at the back end of the approval and licensing process. And the importance of statements of concern, because not only do those get your information and your concerns before the director, but essentially that's your ticket in the appeals door, if you ultimately in the long run want to appeal whatever decision the director may come up with in relation to the approval or the license. And the other piece is to consider outside strategies, to look at what the broad toolbox is and recognize that engaging in the regulatory process is only one piece. And so what are the different tools that you might use to be able to achieve the outcomes that you're looking at, to influence the decisions made on an application. So just to remind people, we do have 3 more webinars coming up in this series dealing with the decision making under the Environmental Protection and Enhancement Act and the Water Act. So next Thursday, Jason Unger, who's the author of the guide, will be dealing with appeals to the Environmental Appeals Board in relation to approvals and licenses. On February 18th, we will be having Adam Dryzik of our office dealing with public participation in environmental impact assessments, and we touched on that briefly. And EIAs tend to come into play early on in the decision-making process, but Adam will cover off how that participation occurs, because it's a bit different than this one. And on February 25th, Laura Bowman of our office will be covering off going to court or judicial review. And so how does the court remedy fit into all this, and how can it be used? So just to put in our plug, as you would have seen in the earlier slides, the Environmental Law Center is a registered charity, so we are able to receipt for people. 100% of your donations help fund our program, so things like this. This series of presentations, actually, we have got the support of the Alberta Law Foundation, who is one of our long-term supporters, but certainly any support that people are willing to give us in terms of donations is greatly appreciated and goes to support our the whole range of public activities that we carry out. So keep that in mind if you like what we're doing, you think we're doing a good job. And we've got a whole range of ways in which you can contact us and access our information. So we'll leave that up there while we deal with the questions. Certainly our web page, but we've got a blog and Facebook and the Twitter. In terms of the audio from this, as well as the slideshow, will be posted up in the next day or so, and you will be able to access that through our website. So if you visit our website, it will provide you with the links to be able to access today's information. So what we'll do is take a few minutes now to deal with the questions. Okay. Sorry, Adam just sent me a note. Thank you, Adam. I have got these flipped up just in case anyone's interested. I flipped them up. Adam is actually dealing with judicial review on the 25th, and Laura Bowman will be presenting the EIA piece on the 18th. So my mistake. Sorry, Adam. I got them mixed up, but they will both do wonderful jobs, I know. So we'll move on to the questions. I know Leah's going to pass them through. There is this first one on that Noreen has posted about what happens once an application or a license is approved, but environmental concerns do not become evident to relevant stakeholders until the activity has begun or has been in operation for some time. That's a really good question, Noreen, and it's a challenging one. The director does have the power under the legislation to be able to go in of his or her own accord and amend the authorization, but that power is fairly limited in terms of that it has to be in relation to something that wasn't apparent or discoverable at the time that the initial application was going through. So it puts some onus on the director to do their job at the outset, because otherwise, and part of the reason around that is that it's an issue of fairness, and part of what the legislation is looking to do is to give the operator the certainty once they've got an approval or got a license that that's not going to be changed on them, intermittently or without some good reason. So there is some ability in the director to be able to go back in and amend the license. There is also the power under the Act, and this is more so of, I don't know if enforcement is necessarily right. There are some enforcement and compliance tools that are available to the director. So, for example, there's a tool called the Environmental Protection Order, and that's an order that can be issued by the director in relation to where there may be potential environmental harm. So it can be a tool. There doesn't necessarily have to be harm happening. It can be prospective in nature. And that order, the director cannot use that order, the Environmental Protection Order, what's termed an EPO. That can be used even if an operator is in total compliance with their approval or their license. So that's a tool that's available there. There also is what's termed an enforcement order. Now that is a tool, an enforcement tool that can be used by Alberta Environment if an operator's not in compliance with the Act or not in compliance with their approval or license. So there are some tools there, but it's to some extent the ability to change and make revisions to the application or the license is not really broad. It has to be pieces that were not brought to the front or not knowable or not available at the time that the application went through. Any other questions, Leah, that you've got there? How does one find notices of director's decision and information about submitting statements of concern? Okay. Now, in terms of the information about submitting statements of concern, generally speaking, that is going to, the main place that you're going to see that is going to be in relation to the public notice that has to be provided, and very commonly that's run in newspapers. So if you're aware of that there is a proposed activity, part of what you're going to be watching is that you're going to be watching the newspapers. Alberta Environment does also have available on their site, they have what's termed a regulatory approvals viewer. So that does provide some information in relation to approvals. I'm not certain that they post the notices about submitting statements of concern. So really what you want to watch for are those notices, which are commonly in the newspaper. Other ways that they can be made available other than by the newspaper. Can also be, depending on, sometimes if it's a really big project, an applicant may do direct mail out to people in the area, but I wouldn't necessarily count on that. Sometimes it will provide for things like posting in, like say if it's a smaller community, they may provide for it to be the notice to be posted in say the local municipal hall or the local post office, something like that. But most commonly it's been a notice in the newspaper. Often they may need to run it a few times to do that. So part of it is really to be on your toes in terms of watching where notices are for. And I've seen them show up. I'm a daily reader of the Edmonton Journal, and I've seen them show up in different spots in the Journal. Sometimes they'll show up in the classified section. Sometimes they'll show up in the business section. It varies. Generally speaking, you're going to look for something that's got so that it may say Alberta Environment on it, or some have say notice of application under Environmental Protection Enhancement Act or Water Act. In relation to notices of the director's decisions, generally speaking, because the legislation requires the director to give that direct notice to the applicant and to the people who receive statements of concern, there may not necessarily be anything out publicly. So what you may want to do then is say you filed a statement of concern and the director said, no, I don't think you're directly affected, and you want to be tracking that. What you can do is either, if you have contact with other people who are engaged in the process, to try and track it through them, or, for instance, you may just have to, say, put in the practice of contacting Alberta Environment every week and asking them, has the decision been issued yet on this, and has the decision been issued yet on that? And doing it that way. It's not a perfect system, and certainly from our perspective at the Environmental Law Center, we think it's rather arbitrary and would really rather see them just doing a broad notice of the decision, regardless of whether or not you're directly affected. Any other questions, Leah? Okay. The minister added some other types of information in addition to those outlined in Section 35. Okay, so what that is, and I'm not certain, I took a look at Alberta Environment's website quickly this morning, and I'm not certain that they have the order posted on their website. But if you were to go into, and you have to dig around the Queen's Printer's website for this, but what they've got is referred to as Ministerial Order 23/2004. And this one is one I'll post this on. We'll post this on the blog as well, so that people can know where it is. And basically, it's got a whole list of information in terms of things that will be made publicly accessible. So, in terms of certain penalties and tickets that can be issued under the Act, records intended as statements of concerns, notice of a decision of the director, records and reports required under a code of practice. So where someone's operating under registration, which we referred to earlier. So while that doesn't have a public participation element, if they're required under that code of practice to submit reports, and you're wanting to have a look at how they're operating and what their reports are saying, you can have access to that type of information about the environmental condition of sites, so largely where it's gearing towards contaminated land, some information in relation to transporters and consigners of hazardous waste. So it's a fairly broad range of information. But what I will do is I will post some more details on this order on the blog, and ideally point you to where you can access it via the web if it's web accessible. I believe it is, but it may take a little digging. So we will look to track that down and post that on the blog. Leah? Okay, so that's it for now. So thank you so much for everyone, especially for your patience with the tech challenges, and hopefully we won't run into that problem on the future webinars. So we invite you to, if you're keen on this, to return on the following Thursdays for the rest of this month for our future webinars. If you think of questions after the fact, please feel free to send them in either to me or to Leah or to our general email, and they will make their way to us. So thank you very much to everyone for dialing in today, and we hope to be online with you again.